Hello everyone, welcome to my channel. Today we'll discuss some important facts about selling an ancestral property in India. So let's get started. To understand that, first of all, we need to understand that real estate properties, being one of the costliest assets, have always been a reason of disputes between family members. In India, people are allowed to use and sell their ancestral properties only under certain circumstances. Unlike a self acquired property that is purchased by investing in one's hard earned money, an ancestral property is the one that has been acquired from forefathers or at least four generations of male lineage. At the same time, real estate properties acquired from the maternal family are not considered as ancestral property. Earlier, only sons were allowed to inherit these properties, but since the legal amendment in 2005, even the girls are allowed an equal share to it. The very first important question is what and how your share in the ancestral property is decided. The share of a person in his ancestral property is determined based on the number of co-personers. Both son and daughter have equal rights on the property acquired from a predecessor. But the same rules does not apply in the case of self-acquired property of a father. The rights in ancestral property are determined by share of each generation and your position in the family tree. Now, who can sell the ancestral property? Anyone can sell ancestral property which is under his or her share, but before selling the property, he/she needs to acquire its ownership. And a co-personer cannot sell a joint property without getting the permission of other family members or heirs. Second, the head of the Hindu undivided family can manage the property and he can sell it under certain circumstances only, such as distress and the sake of the family. But this does not mean he/she has an independent right over the property, as every co-person is entitled to getting his or her share in the property. Important factors to analyze before selling an ancestral property. Title of the property. The seller should confirm that the property is in his name and he should have a partition deed or a legal will to prove the same. Next is the property tax. Before selling any ancestral property, you should have paid all the pending taxes related to it. Free from legal disputes. The ancestral property should be free from any dispute. This means no one should claim a share in it. No objection certificate. In case you do not possess a legally acceptable will that provides your right on the property, you should obtain a no objection certificate from all the legal heirs. The most important thing to note is if an heir is denied a share in the ancestral property, then he or she can send a legal notice demanding the same. If this does not work, he should file a suit for partition in civil court. In case the property has been sold by another co-personers, you can still claim your share in the money obtained through selling the property. The above mentioned rules regarding the acquisition and the sale of ancestral properties in India are equal applicable to Jains, Sikhs and Buddhists. Now, the conclusion. Before selling any ancestral property in India, you should acquire its ownership by obtaining a legal will, NOC, or a partition deed. Every legal heir gets equal rights on the property irrespective of his gender, his income status, or any other factor. In case of an emergency or distress, even the head of the Hindu undivided family is allowed to sell the ancestral property. If you like the video, do like and subscribe. Thanks for watching. Take care. Bye bye.